So let's continue our lecture on intellectual property law. Particularly, we are still with patent, correct? No? So just to recap, para lang ma-remind lang tayo what we have already discussed. So last time or last lecture, we are through with the general concept of patent, correct? So what are those that are considered as patentable inventions? The classes, no? The classes of patentable inventions. What else? The purpose. Of course, no? So, para mas madali nating maunawaan yung inaaral natin, kailangan alam din natin ano nga ba yung purpose ng patent, no? Parang ano lang 'yan sa pag-aaral natin ngayon, no? Kung medyo nahihirapan ka na, babalik ka lang dun sa purpose mo, no? Babalik ka dun sa purpose mo, ba't ka nag-aaral. Okay? Ganoon din dito. So, we are through with the purpose or ang natatandaan ko pa, ang diniscuss natin dito yung threefold purpose ng patent. Of course, the ultimate goal is to bring those inventions, those novel inventions into the public domain. Di ba? Yan yung sinasabi natin. So we are also through with the requisites, no? The requisites of a patent. So it must be novel. It must not be part of a prior art. Correct? What else? It must involve an inventive step. And lastly, it must be industrially applicable. Okay? So, dapat nasa tip ng fingers mo yung mga requisites na yan. Sobrang dapat kabisado mo na. Okay? So, we are also through with respect to application for a patent, no? For a patent, yung concept ng first to file rule. Okay? Yung distinction niya sa right of priority. So hindi lang yung first to file rule ang susundin, tignan mo rin kasi baka applicable yung right of priority. And also with the first to file rule na discuss na rin natin or I gave you an overview of the process of application of a patent. So you must now be familiar that the application date is not always the same date nung application mo kung kailan mo sinubmit. 'Di ba? May technical consequence or may technical meaning yung application date. In fact, dun nga sa process, no? Sa process ng patent application, meron nga dun tinatawag na accordance of application date. Okay? So tandaan yung mga rules na yan. What else? We are also through with prejudicial disclosures. So kung may prejudicial disclosures, meron din tinatawag na non-prejudicial disclosures, giving the inventor a grace period of 12 months. Okay? What else? We are also through with the rules with respect to rights, no, ng patent, rights to a patent, especially if an invention was made under an employer and employee relationship. So, just familiarize yourselves with those rules, grounds for cancellations, etc., etc. Lahat nung na-discuss na natin last time. So, recap lang yan para ma-refresh lang muna kahit papaano yung memories natin kung saan na tayo natapos. 'Di ba? Sa kakapaulit-ulit, sa kakasabi ng kakasabi, hindi mo namamalayan, nakakabisa mo na rin yan. Okay? So let's proceed with our next topic under patent. Of course, yung patent infringement. Di ba? So dito na tayo sa kung tutuusin yung in a way myth ng patent. No? So how do we determine if there is a patent infringement? Okay? So first, we must define what a patent infringement is. So patent infringement is the making, using, offering for sale, selling, or importing a patented product, no? Or a product obtained directly or indirectly from a patented process or the use of a patented process without the authorization of the patentee. So, ano ang mga keywords, no? Ano ang mga keywords? So, even if you are just making, you are using and offering for sale or importing a patented product, okay, or a product obtained directly or indirectly or the use of a patented process without the authorization of the patentee. So obviously, patent infringement is the non-respect of the patentee's rights over his or her patentable invention, no, over his or her invention, or for that process or invention covered or protected by a patent right. Okay, so whether it be making, using, offering, selling, okay, or even importing a patented product or the use of a patented process, it will constitute a patent infringement. Okay? So, how do you determine if there is an infringement? So meron tayong tinatawag na tests of infringement. So, meron tayong tinatawag na literal infringement. No? Yung first test natin is the literal infringement. So, pag sinabing literal infringement, so you made, you used, you sold a patent literal, no? A product or process protected by a patent literal. So one makes, uses, or sells an item that contains all the elements of a patent claim. Okay? So in determining whether there is a patent infringement, so again, in determining whether there is a patent infringement, determine first if there is a literal infringement. Okay? So kung literal infringement, precisely or obviously, the defendant or the suspect, the accused, is liable for patent infringement. So uh, in applying literal infringement, you must first satisfy the exactness rule or addition rule. So, pag sinabing exactness rule, the item that is being sold, made, or used conforms exactly to the patent claim of another. Kinopya talaga. Or pag sinabing addition rule, one makes, uses, or sells an item that has all the elements of the patent claim of another plus other elements. Okay? Tandaan mo ha, all elements of the patent claim of another plus other elements. So that's literal infringement. Sir, pwede rin ba na hindi literal infringement, eh, magiging liable pa rin ako for patent infringement? Yes. If upon determination that there is no literal infringement, apply the next test. No? If there is no literal infringement, then apply the next test. Anong test yon? The doctrine of equivalence. So sir, kahit pala walang literal, as in hindi ko totally kinopya, pwede pa rin ako maging liable for patent infringement? Yes, by applying doctrine of equivalence. What is doctrine of equivalence? An infringement that takes place when a device appropriates a prior invention by incorporating its innovative concept and although with some modification and change, performs substantially the same function in substantially the same way to achieve the same result. So, may modification man, no? May modification, may unti kang binago, no? May unti kang binago dun sa produkto mo or dun sa concept na yon. However, yung innovative concept ng iba, kinopya mo, kinuha mo. Pero ang end goal mo pa rin ay to perform substantially the same function nung pinagkopyahan mo and to achieve the same result nung pinagkopyahan mo, then the doctrine of equivalence will apply and that person will be held liable, can be held liable for patent infringement. Okay? So by definition ng doctrine of equivalence, may kita mo agad na ang importante is the function and the result. So apply the function, means, and result test. So this is the principle or mode of operation must be the same or substantially the same doon sa unang or doon sa previous na patentable or protected invention by a patent right. So si patentee has the burden to show that all three components of equivalency test are met. So kung halimbawa si A, no? Kung halimbawa si A ay meron na siyang patent over a particular invention, tapos si B kinopya 'yon, no? However, minodify naman ni B. Hindi niya literal na kinopya, no? Hindi niya literal na kinopya, minodify ni B. However, yung ginawa ni B actually used the innovative concept protected by A's patent. plus yung result at yung function ng invention ni B ay kapareho ng invention ni A. Sino ang may burden na si B ay uh, liable for patent infringement by applying doctrine of equivalence? Si A, si patentee. Okay? So, si patentee has the burden to show that all three components of equivalency test are met. So, ano uli yun? Si function, si means, tsaka sa result. Okay? So remember that the doctrine of equivalence will only be applicable if there is no literal infringement. Okay? If there is no literal infringement. So, under the doctrine of equivalence, the principle or mode of operation must be the same or substantially the same, applying the function, means, and result test. Okay? Ano ngayon yung remedy? No? Ano ngayon yung remedies ni patentee? Sabihin mo na, no? Na-deprive siya ng patent ownership. Okay? Na-deprive siya ng patent ownership. Kung siya yung first filer, no? Under Section 67, in reference to Section 29 ng Intellectual Property Code. So within 3 months, after the decision has become final, the first filer may prosecute the application as his or her own application in place of the applicant. So, he or she may file a new patent application in respect of the same invention and request that the application be refused or seek cancellation of the patent if one has already been issued. So, remember class, so last time dun sa discussion natin, naalala ko may nagtanong sa class niyan no? Uh, remember na pinapublish yan, no? Application pa lang, pinapublish na, pwede kang mag-oppose. At in fact, even in the event that the IPO has already issued letters patent in favor of a person, you can still oppose, no? You can still oppose. May remedy ka pa rin. Okay? How about kung ang na-deprive naman ay yung true and actual inventor? So if a person who has deprived of the patent without his or her consent or through fraud is declared by final court order or decision to be the true and actual inventor, the court shall order for his or her substitution as patentee. So kahit pa na issuehan na yung particular person ng patent right, however, yung true and actual inventor was deprived by such person, then the court may order that such true and actual inventor be the substitute to the patentee. No? So the court shall order for his or her substitution as patentee or at the option of the true inventor, cancel the patent o pwede niya pa ipa-cancel and award actual damages in his or her favor if warranted by the circumstances. So may two options. So, tandaan mo ha, pwede siyang maging substitute or pwedeng gawin niya, pa-cancel niya yung patent. Okay? So, tandaan yung mga rules. Okay? Yan yung remedy ng true and actual inventor who was deprived of patent ownership. Okay? Next. Next. Okay, remedies against infringement. Remember yung definition natin kanina, no? Itong first part, ang tinutukoy product. Di ba? Even ito, patented product or even that product obtained directly or indirectly from a patented process. Okay? Or the use or even the use of patented process. So, you must identify whether the infringement involved a product, a patented product, or a patented process. So, kasi in applying remedies against infringement, magkaiba. Okay? Magkaiba yung pamamaraan. You must first identify whether the subject is a product or a process. So if the subject of an infringement is a product, the patent owner has the right to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. So, naalala mo pa yung kaso natin sa Pearl and Dean, no? Kung sakali man sana, sabi ng Supreme Court, na napapatent mo yun, including the product, sana si Pearl and Dean, magkakaroon siya ng right to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sales, selling, or importing the light boxes or the advertising light boxes. No? Pag-process naman, the patent owner has the right to restrain, prevent, or prohibit any unauthorized person or entity from using the process and from manufacturing, dealing in, using, selling, or offering for sale or importing any product obtained directly or indirectly from such process. So kung mapapansin mo, pag process ang protektado ng patent right, yung protection over that process not only covers the process but also the product obtained from that process, whether indirectly or indirectly. So tandaan mo ha, o pag-process mas malawak yung coverage kasi pag-process hindi lang yung proseso ang pinoprotektahan. Even yung product made, no? Even yung product made or obtained directly or indirectly, sorry, obtained directly or indirectly from such process is also protected, no? So may right pa rin si patent owner. Okay? How about civil action? So nandito na tayo sa mga remedies, no? Iba't ibang remedies. Paano mo nakakasuhan yung nagnakaw, no? Infringement in a way, no? Nagnakaw in a way dahil patent infringement. So, pwede kang mag-recover from the infringer of such damages sustained because of the infringement plus attorney's fees or other cost of litigation. Uh, you can also secure an injunction for the protection of your right over a particular invention. Pag sinabing injunction, pwede mong ipatigil, no? Pwede mong ipatigil yung kagaya nung ginawa ni ano, 'di ba? Ni Pearl Indin. Pero yun, sulat lang yun, 'di ba? Tapos tumigil muna si SM. Ngayon, kung injunction, i-apply mo yan sa court. Kaya court yung magbabawal na, oy, bawal muna kayo magbenta niyan, ha? Papatigil mo, pwede. Or kung ayaw mo naman patigil, pwede kang mag-file ng reasonable ng civil action for reasonable royalty. Kumbaga, gusto mo na rin sigurong mapakinabangan ng invention mo at ibenta na nga. Pero syempre, dahil ikaw naman yung inventor, dapat naman makinabang ka, no? Magkaroon ka man lang ng pakinabang dun sa invention mo. Pecuniary advantage. Okay? So, reasonable royalty. At yung civil action for infringement prescribes within 4 years, no? Ay, after 4 years, sorry. Not within, no? So, after 4 years. From existence of cause of action, of course. Di ba? Next, presumption, no? Meron tayong presumption with respect to infringement. So, if the subject matter of a patent is a process for obtaining product, any identical product shall be presumed to have been obtained through the use of the patented process. If the product is new or there is substantial likelihood that the identical product was made by the process and the owner of the patent has been unable, despite reasonable efforts, to determine the process actually used. So, presumed, no? Ulitin natin. If the subject matter of a patent is a process for obtaining a product, any identical product shall be presumed to have been obtained through the use of the patented process if the product is new or there is substantial likelihood that the identical product was made by the process and the owner of the patent has been unable despite reasonable efforts to determine the process actually used. So, presume ka, no? Presume ka na ginamit mo yung patented process. May presumption. So, in ordering the defendant to prove that the process to obtain the identical product is different from the patented process, the court shall adopt measures to protect as far as practicable his or her manufacturing and business secret. So, kung mapapansin mo, dahil may presumption, na kay defendant ngayon yung burden to prove, no? Na different yung process na ginamit niya para dun sa identical products na pwedeng manggaling dun sa patented process. So baligtad, no? Baligtad. Uh, Kasi may binigay na presumption yung batas. Of course, 'di ba? Sabi nga natin, yung doon sa purposes, no? Doon sa purposes ng patent right, while the state endeavors that the inventions or the novel inventions be brought to the public domain, ang kapalit naman nun si government poprotektahan ka niya, no? Poprotektahan ka niya. At para ma-encourage, in fact, kung merong identical product na galing do sa patented right, I mean, hindi pala ma-determine kung galing dun sa patented right kahit pa through reasonable effort ni patent owner, presumed na yung product na yun ay galing nga doon sa patented process. So si defendant ngayon, ang may burden to show that the identical product is different from the patented process. Okay? Next. What else? Damages cannot be what else sa presumption na damages cannot be recovered for acts of infringement committed before the infringer had known or had reasonable grounds to know of the patent, no? So kung hindi naman niya alam, no? Uh, hindi siya pwedeng masingil ng damages. However, no? Sir, paano hindi niya malalaman kung publish? O, 'di ba? 'Yun ang ano doon. 'Yun ang problema doon, no? Kaya mahirap kasi in fact class, natatandaan mo pa no, kung yung nag-aaral tayo ng intro to law natin, that publication is a notice to the whole world. So you cannot feign ignorance, no? You cannot feign ignorance, then claim later on that you do not know of the existence of that patent. If that issuance of patent or letters patent was published. Kaya napaka-importante nung publication. Eh, no? Okay? So it is presumed that the infringer had known of the patent if on the patented product or on the container or package in which the article is supplied to the public or on the advertising material related to the patented product or process are placed the words Philippine patent with the number of the patent. So ito pa, no? So ma-overcome din to kung yung mismong product ay may tatak na Philippine patent with the patent number. Ewan ko kung napapansin mo yan, no? Though matagal na rin akong hindi umiinom ng soft drinks, no? Yung isang brand ng soft drinks, yung may bote siya. Tapos, bote siya, I don't know, parang plastic na rin yata lahat ngayon, no? Yung label, pag tinignan mo yung label nun, may nakalagay doon, no? Yung Philippine patent, Philippine Pat Off, nakalagay lagi, no? Philippine Pat Off, Philippine Patent Office, gano'n. Philippine Pat Off number, blah, 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 blah. O, yun. So, notice na yun kung tutusin na patented. Sir, ano yung patented dun? Pwede yung bote, no? Yung bote, o, yun. Patented. Hindi mo pwedeng gamitin sa kung saan-saan. No? So, notice na yun sa'yo na patented yun. Okay? Next. How about criminal action? So, kanina, ang tinutukoy natin, civil action. No? Civil action. Pag criminal action, pwede rin ba? Yes, pwede rin. Sir, ba't ko pipiliin yung criminal action? Kasi baka gusto mong ipakulong. No? Baka gusto mong ipakulong. So if infringement is repeated by the infringer or by anyone in connivance with him or her after finality of the judgment of the court against the infringer, the offender shall, without prejudice to the institution of a civil action for damages, be criminally liable therefore. So dito pa lang mapapansin mo, no, na maa-avail mo lang ang criminal action kung si infringer is a repeat offender. No? Kung si infringer is a repeat offender, then you can institute criminal action. Tandaan ang sinabi ng batas, if infringement is repeated by the infringer. So, if the infringer is a um, repeated offender, then you can file a criminal action for infringement. So, upon conviction, the infringer shall suffer imprisonment for the period of not less than 6 years but not more than 3 years, and or a fine of not less than 100,000 but not more than 300,000 at the discretion of the court. So kung kanina ang civil action nagpe-prescribe after 4 years, pag criminal action nagpe-prescribe in 3 years from the date of the commission of the crime. Sa civil action, from the date the cause of action has accrued. Okay? Next. Limitations as to patent rights. So under Section 72 on the Cheaper Medicines Act of 2008, so using a patented product which has been put on the market in the Philippines by the owner of the product or with or his or her consent, insofar as such use is performed after the product that has been so put on the said market. Okay? That provided that with regard to drugs and medicines, the limitation on patent rights shall apply after a drug or medicine has been introduced in the Philippines or anywhere else in the world by the patent owner or by any party authorized to use invention. Provided further that the right to import the drugs and medicines contemplated in this section shall be available to any government agency or any third party. So, isa yan sa limitation ng patent right with respect to medicines. No? Tandaan mo, using a patented product which has been put on the market in the Philippines by the owner of the product with his or her express consent insofar as such use is performed after that product has been so put on the said market. O hindi ka na pwede mag-claim ng patent right over that product. Remember, ang purpose din kasi ng Cheaper Medicines Act is to lift the restrictive provisions with respect to medicines. Kasi habang nire-restrict natin yung patent over particular medicines, hindi makakagawa yung ibang manufacturer na kagayang medicine. Di ba? At ang magiging resulta nun, mataas ang presyo ng mga medisina. Pero kung yan ay in-out mo na sa market, no? Pwede nang kaya nga nagkaroon na ng generic brands ng medicine yun. Napansin mo ba 'yon, 'di ba? Biglang dami yung generic brands ng medicine dahil sa Cheaper Medicines Act. Okay? So tandaan mo 'yan with respect to medicines. Yan yung mga limitation sa patent rights. Okay? What else? Where the act is done privately and on a non-commercial scale or for a non-commercial purpose, provided that it does not significantly prejudice the economic interest of the owner of the patent. O, pwede rin. So, kung non-commercial scale or non-commercial purpose, nag-produce ka uli ng mga medicine, provided that it does not prejudice the economic concern, pwede. No? Limitation pa rin yun sa patent right. Remember, ang paano siya magiging hindi prejudicial sa economic interest ng owner ng patent? It must be non-commercial in nature. Okay? Non-commercial scale and non-commercial purpose. So, dapat non-commercial in nature. Okay? So, where the acts consist of making or using exclusively for experimental use of the invention for scientific purposes or educational purposes and such other activities directly related to such scientific or educational experimental use. So, for educational purposes, ginamit mo yung drugs, no? Pagpalagay mo na yung itong COVID vaccine, no? Yung COVID vaccine, ginamit mo yung mga available COVID vaccines for experimental use, for scientific purposes or educational purposes. Uh, will it violate the patent right of the manufacturer over that COVID vaccine? Answer, no. By virtue of the Cheaper Medicines Act of 2008. In fact, limitation yun sa patent right nung manufacturer nung vaccine na yun. Okay? Next, in the case of drugs and medicines, where the act includes testing, using, making, or selling the invention, including any data related thereto, solely for purposes reasonably related to the development and submission of information, and issuance of approvals of government agencies required under the law, or any country that regulates the manufacture, construction of any product. So, yun pa rin, no? So, tandaan mo lang naman, no, yung limitation sa patent rights. Kung tutusin, wala pa naman kasi hindi siya pinagkakakitaan eh. In fact, dito sa exception na to, ang main purpose niya is related to the development and submission of information and issuance of approval by a particular government regulatory agency. Okay? Provided that in order to protect the data submitted by the original patent holder from unfair commercial use, okay, in consultation with blah 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 blah, The Intellectual Property Office shall issue appropriate rules and regulations necessary therein not later than 120 days. So, parang inutusan lang naman dito yung IPO to issue an IRR. Okay? Next. What else? Where the act consists of the preparation for individual cases in a pharmacy or by a medical professional of a medicine in accordance with a medical prescription or acts concerning the medicine so prepared. So, hindi rin siya patent infringement. What else? Where the invention is used in any ship, vessel, aircraft, or land vehicle of any country entering the territory of the Philippines temporarily and accidentally, provided that such invention is used exclusively for the needs of the ship, vessel, aircraft, or land vehicle, and not used for the manufacturing or of anything to be sold within the Philippines. Okay? So just familiarize yourself with the exemptions or limitations of patent rights under provided under the Cheaper Medicines Act. Okay? What else? With respect to prior user, no, with respect to prior user, any prior user who in good faith was using the invention or has undertaken serious preparation to use the invention in his enterprise before, no, before the filing date or priority date of the application shall have the right to continue the use thereof as envisaged in such preparation within the territory where the patent produces its effect. The right of the prior user may only be transferred or assigned together with his or her enterprise or business with that part of his or her enterprise or business in which use or preparations for use have been made. So, kung i-assign daw, no? Kung i-assign daw ni prior user yung kanyang right to prior use or right niya as a prior user for that particular invention, ano ang limitation? Kasama niyang i-assign yung enterprise or business niya. Okay? Yan yung sinasabing limitation with respect to a prior user. Okay? So kailangan kung i-assign niya again, the right of the prior user may be only be transferred or assigned together with his or her enterprise or business or with that part kung hindi man buo ng business or enterprise niya, yung part ng enterprise or business niya which the use or preparations for use have been made. Okay? Next. Ano pa? O kapag yung invention mo ginamit ng government. Okay? Pag yung invention mo ginamit ng government, hindi yun patent infringement. Sir, kahit protected ng patent right? Yes. Okay? Under Section 74. Okay? So a government agency or third person authorized by the government may exploit the invention even without the agreement of the patent owner. Lagi ba? Pwede bang makialam ang gobyerno? Of course, hindi. No? Meron lang particular instances kung kailan pwedeng makialam ang gobyerno without infringing your patent right. Kailan? Where the public interest, in particular national security, nutrition, health, or the development of other sectors, as determined by the appropriate agency of the government so requires, or a judicial or administrative body has determined that the manner of exploitation by the owner of the patent or his or her licensee is anti-competitive. So, tandaan mo ha, kapag anti-competitive, pwede nang kunin ng gobyerno yan. No? Of course, upon administrative or judicial determination. Okay? So kung administrative yan, anti-competitive, anong mangyayari? Sino ang makikialam? O, dapat alam mo na ang sagot. PCC. Di ba? So tapos ka na ng Philippine Competition Act o the PCC. What else? Again, under the Cheaper Medicines Act, sinabi din na pag-use ng government, no, inamend yan ng Cheaper Medicines Act. So, kaya tandaan mo ha, pwede rin pakialaman ng gobyerno. Okay? Balik ka sa rason uli ng Cheaper Medicines Act kung bakit, no? Oh. So, mas madali mo siyang intindihan. So, in the case of drugs and medicines, there is a national emergency or other circumstance of extreme urgency requiring the use of invention. So, limited din ang patent right mo. What else? There is a public non-commercial use of the patent by the patentee without satisfactory reason. In the case of drugs or medicines, the demand for the patented article in the Philippines is not being met to an adequate extent and reasonable terms as determined by Secretary of the Department of Health. In situations of national emergency or other circumstances of extreme urgency, the right holder shall be notified as soon as reasonably practicable. What else, no? Actually, pwede nyo na rin naman nang basahin na lang to, no? Kasi nga, ito yung exclusive, eh, no? Kumbaga, ay, hindi. Actually, wag natin gamitin yung term na exclusive. Ito yung enumeration, no? Ito yung enumeration ng law, eh, no? Ng limitation ng patent right. Especially with respect to the Cheaper Medicines Act. So, I remember na during one of our asynchronous lecture, pinrovide ko naman, no? Pinrovide ko naman yung copy ng Intellectual Property Code as amended. So, if you are more uh, if it would be more convenient for you to just read the provisions, then go ahead. Okay? So, ito naman nilagay ko lang dito para lang, 'di ba, makita mo pa rin. Baka kasi kung babasahin mo lang yung code, baka di mo pansinin eh, 'di ba? O at least dito, nasabi natin, no? Nasabi natin dito yung mga limitations ng patent rights. Okay? Licensing, okay? Licensing of a patent. So ano-ano yung mga licensing, kinds of licensing of a patent? May tinatawag tayong voluntary licensing at compulsory licensing. So, yung voluntary licensing, yan yung alam natin. Okay? Yung conventional licensing. This is to encourage transfer and dissemination of technology. So, nasabi na nga natin. To prevent practices that may have adverse effect on competition and trade. Prohibited clauses in licensing agreements. So, just review that under Section 87 and the mandatory provisions under Section 88. Okay? Ang compulsory licensing naman is against the will of the patent owner. Okay? Is against the will of the patent owner. So, ano-ano yung mga yon, no? Ano-ano yung mga instances? Ano-ano yung mga instances kung kailan pwedeng pilitin? Kung pwedeng pilitin si patent owner to license, no? To license his or her patent. Para sige ganito, para mas ma-gets mo, no? Feeling ko kasi baka masyado kita namamadali, no? Baka masyado kita namamadali. Baka hindi mo magets bakit natin dinidiscuss yung licensing ng patent. Remember, nabanggit natin na syempre, ano nga ba talaga yung ultimate goal din ni inventor, 'di ba? Kapag siya ay nakakagawa ng novel invention. Of course, para in a way magkaroon naman din siya ng monetary compensation for that invention. Kaya nga siya binibigyan ng right, eh, 'di ba? To have an exclusive use of that invention by virtue of the patent right. In fact, patent infringement constitutes the making, selling, using of that product without the authorization of the inventor, correct? Oh, yung pag-authorize ni inventor, ni patentee to make, to use or to obtain products directly or indirectly from that patentable process, yun yung tinatawag nating licensing. Yan ha, o yan para lang magkaroon ka lang na idea kasi baka di ko namamalayan, namamadali na kita, binibigyan na lang kita ng overview, no? So, yun yung meaning ng licensing. Kumbaga, kung ikaw si inventor, papayagan mo na mag-produce ng produkto halimbawa galing do sa patented process mo si other person. Pero siyempre, of course, dapat may kita ka dun. O yung kontrata nyo, kung ano man yung pag-uusapan nyo, na papayagan mo na siya na mag-produce ng kung ano-anong produkto galing dun sa patented process mo, yun yung tinatawag na licensing agreement. Kaya nga siya voluntary licensing eh. Tsaka kaya nga siya tinawag na conventional licensing. So, pinag nag-usap, no? Nag-usap sila. So, isa to sa way ng inventor naman na makakuha ng economic benefit. Okay? Doon sa naimbento niya, doon sa innovative process, product niya. Okay? So by granting the authority uh, to another person enterprise to commercially exploit the invention made by that patentee, or by manufacturing, by making, using, selling that product, o yan yun. Diyan siya kikita, diyan sa licensing. Okay? Yan yung para lang may concept ka ng licensing. Ngayon, may mga tinatawag tayong prohibited clauses in licensing agreement. So, kagaya nung napag-aralan natin sa obligations and contracts, di ba? Naalala mo yung sa contracts? Yung parties can stipulate whatever under the sun. Di ba? Provided that it must not be contrary to law, morals, public order, public policy, etc. etc. Di ba? O ganun din dito. So, pwede kang mag-voluntary licensing with another enterprise, another person, whatever, whoever you want, no, to uh, enter into conventional licensing. Kaya nga siya voluntary. However, there are prohibited clauses. Okay, there are prohibited clauses. So, what are those prohibited clauses? So, under section 87, no? Under section 87. Okay? So, isa-isahin mo yan. Example lang, no? Example lang. Those which impose upon the licensee the obligation to acquire from a specific source capital goods, intermediate products, raw materials, and other technologies or of permanently employing personnel indicated by the licensor. Bakit? Kasi anti-competitive to. Di ba? Alam na alam mo na yung concept ng competition. Correct? Those that contain restrictions regarding the volume and structure of the production, again, anti-competitive provision or stipulation, so hindi pwede. Okay? So, it's for you to go over that part, yung prohibited clauses, and familiarize yourselves. Okay? How about mandatory provisions? Or for example, under Section 88, no? That the laws of the Philippines shall govern the interpretation of the same. So parang ano lang siya, no? Nire-require lang ng law na i-incorporate mo doon sa contract mo with another enterprise or your prospective licensee. Okay? Ngayon, ano naman yung compulsory licensing o kabaligtaran? Kung kanina ikaw, kung ikaw kanina nag-iisip ka na kumita ka na sa invention mo kaya ka makikipag-agree to another person o to another person and kumita ka naman, dito naman sa pilitan. Sa pilitan. So, dito, awarding of licenses are given against the will of the patent owner. Okay? So, sa ano yung mga pagkakataon na pwede kang pilitin ni nabigyan na o mag-issue ka ng license, no? O diyan. Karaniwan siyempre, estado ang makikialam, no? Estado ang makikialam diyan. Gobyerno lang naman karaniwan ang makakapagpilit sa iyo, 'di ba? Na gawin ng mga bagay-bagay. O isa sa mga grounds diyan, halimbawa, national emergency. Okay? Where the interest of the public is involved, particularly national security. Yung kanina, yung binanggit natin sa Cheaper Medicines Act, no? Sa Cheaper and Quality Medicines Act o uh, kung meron naman non-commercial use or production, no? Non-commercial use ng uh, sorry, nawala ko, no? Non-commercial use or production ng patented medicine, pwede. Pwede kang pilitin. Okay? Okay. So, yan. So, familiarize yourselves again with the grounds with respect to compulsory licensing under Section 93. Okay? Assignment of rights. Assignment of rights ng patent. So patents or applications for patent and invention to which they relate shall be protected in the same way as the rights of the other property under the Civil Code. Remember, nung nag-i-intro pa lang tayo ng intellectual property, no? Nag-i-intro pa lang tayo ng intellectual property. Tinatawag nga natin tong intellectual property rights eh. So, pag sinabing right, naalala mo pa rin yung napag-aralan mo sa obligations and contracts, 'di ba? All rights are transmissible except those that are personal in nature. 'Di ba? So, kung ito ay property, to ay property right, pwede mo talagang i-assign to. In fact, it shall be protected in the same way as the right of other property under the civil code. So the particular provisions or the relevant provisions of the civil code with respect to the right of other property will apply. So inventions and any right, title, or interest in and to patents and inventions covered thereby may be assigned or transmitted by inheritance or bequest or may be the subject of a license contract. Precisely. Kaya ka nga allowed ng voluntary licensing because as an inventor and as the owner, I should say, as the owner of the patent right, you have also the right to assign or to give license, to give authority to another enterprise or another person to use your patented product, patented process, whatever. Okay? So an assignment may be of the entire right, title, or interest in and to the patent and the invention covered thereby, or of an undivided share of the entire patent and invention, in which event the parties become joint owners thereof. An assignment may be limited to a specified territory. Okay? Form of assignment. It must be in writing, acknowledged before a notary public or other officer, authorized to administer oath or perform notarial acts, and certified under the hand and official seal of the notary or such other officer. So, explicit, no? Explicit requirement. Hindi ka pwedeng magkaroon ng oral assignment ng intellectual property right. Okay? Recording requirement. So the office, pag sinabing office, the intellectual property office. The office shall record assignments, licenses, and other instruments relating to the transmission of any right, title, or interest in and to inventions and patents or applications for patents or inventions to which they relate, which are presented in due form to the office for registration in books and records kept for the purpose. So, actually, pagtsagaan na lang natin to class dahil ito na yung mga technical na requirements no, ng law with respect to patent. Okay? The original documents, together with the signed duplicate thereof, shall be filed and the contents thereof should be kept confidential. If the original is not available, an authenticated copy thereof in duplicate may be filed. Upon recording, the office shall retain the duplicate, return the original or the authenticated copy to the party who filed the same, and notice of the recording shall be published in the IPO Gazette. Such instruments shall be void as against any subsequent purchaser or mortgagee for valuable consideration and without notice unless it is so recorded in the office. So, to summarize, no? Remember na ang requirement ng batas pag mag-assign ka ng intellectual property right is that it must be in writing. Plus, it must be recorded with the IPO. O, yun lang. Para if you want to familiarize yourself with Section 106, then go ahead and go over with Section 106 using the provided copy of the Intellectual Property Code to you. Okay? How about the rights of joint owners? So if two or more persons jointly own a patent and the invention covered thereby, either by the issuance of the patent in their joint favor or by reason of the assignment of an undivided share in the patent and invention, or by a reason of succession entitled to such share, each of the joint owners shall be entitled to personally make, use, sell, or import the invention for his or her own profit. So each joint owner, provided that neither of the joint owners shall be entitled to grant license or to assign his right without the consent of the other owners or without proportionally dividing the process with such owner or owners. Remember din yung concept na assignment of rights sa oblicon, ganun na ganun din. No? So ano ang presumption? Dapat alam mo na kasi matagal ka nang tapos ng oblicon. O, so yung assignment of rights under oblicon will also apply dito sa intellectual property code. Remember, 'di ba? Ano yung effect kapag halimbawa joint, may right si A tsaka si B, kagaya nito, 'di ba? Joint owner sila. So dapat hindi allowed, no? Hindi allowed mag-assign ng right si A without the consent of B. Okay? Or without proportionally dividing the process or such owner. So sana natatandaan mo pa rin yung concept ng assignment of right. Anong effect kung walang ah consent yung other party? O, yung mga ganon. Okay? Next. Utility model. Okay, tapos na tayo sa patent in a way, no? Pero ito naman ay mga pahabol na lang na lesson sa patent. Pag sinabing utility model, ito yung kung tutuusin, hindi pumasa in a way, no? Hindi pumasa as a patent, na mabigyan ng patent, I mean. Tandaan mo, na-discuss natin last time yung process ng patent at in fact, sinabi ng Supreme Court sa Pearl Indian case that yung patent, application for patent ay rigorous, mabusisi, 'di ba? Mabusisi siya compared to a copyright. So kung hindi karaniwan nakapasa yung invention mo para mag-grant ng patent, ang nangyayari, papasa naman siya as a utility model. So ito, image nga to from Ipophil, no? So sabi dun sa Ipophil, secure exclusive rights to your invention. Register your utility model. O yan, tapos binigay niyang product dito, a ladder convertible to iron stand and chair. O, di ba? So, pwede kasing hindi na siya patentable invention kaya hindi siya nag-grant ng patent. Pero pwede siyang utility model. Okay? So, ano nga ba ang utility models? A registrable utility model is any technical solution to a problem in any field of human activity which is new and industrially applicable. Familiar? Yes, para ring patent. However, utility models may or may not have an inventive step. So yun ang importante. Okay? So it allows the right holder to prevent others from commercially using the registered utility model without his or her authorization, provided that the utility model is new based on registrability report. Okay? Pause muna tayo. Let me drink lang. Sorry. Okay, sorry for that. Medyo nasasamid na tayo, no? Okay, so sabi ko nga, ang utility model, para din siyang patent. However, utility model may or may not have an inventive step. Pero sa protection, ganun din, di ba? Kung registered siya as utility model, may protection din siya under the Intellectual Property Code. Anong protection yon? It allows the right holder to prevent others from commercially using the registered utility model. Okay? So compared with invention patents, it is relatively inexpensive, faster to obtain, and with less stringent patentability requirements. So, inexplain natin kanina, no? Na at last time, na pag patent kasi, rigorous no? Rigorous yung ah rigorous yung proseso to comply with the requirements. Okay? So a utility model is entitled to 7 years of protection from the date of filing. So take note of this class, baka matanong. Okay? Baka masingit lang kung sakali man sa lekpa nyo. Okay? Baka masyado tayong pinapaasang di ba? Patent, copyright, trademark. However, kasi a utility model, technically under patent siya. So tandaan mo rin yung mga yan, ha? 7 years ang utility model. Okay? So sabi sa Ching versus Salinas, a utility model is a technical solution to a problem in any field of human activity which is new and industrially applicable. It may be or may relate to product, process, or an improvement of any of the aforesaid. So, in-explain na Supreme Court yung concept ng utility model sa Ching versus Salinas. Essentially, a utility model refers to an invention in the mechanical field. So, take note of this. Pagpasensyahan nyo na rin ako, class, kung napapadalas na yung pag-quote ko ng Supreme Court decisions kasi kagaya nga nung isang classmate yung nag-raise no, ng concern na nakarating din sa kanya yung balita ng LECPA last batch. Sabi, may mga nababanggit na daw doon na galing sa mga Supreme Court decisions. No? So, baka kasi nasa textbook naman siya, pero baka hindi lang na-quote particularly ng particular textbook na yan. Okay, pero yung concept malamang sigurado nakuha ng author 'yon, 'di ba? Nakuha ng author 'yon. I don't know kung may mga OA na terms na siguro hindi lang nabasa din nung or first time kita no examine tapos may nagbulong na galing Supreme Court decision. O sige, di pasadaan na lang din natin. Okay? Kaysa ipa-assign ko pa sa inyo, 'di ba? Di pasadaan na lang natin yung relevant Supreme Court decisions. Okay? So, let's continue. A utility model varies from an invention for which a patent for invention is likewise available on at least three aspects. So, kagaya nito ha, diniscuss ng Supreme Court dito yung pagkakaiba ng patent sa utility model. Okay? Yung patentable invention sa utility model. Ano daw? The requisite of inventive step in a patent for invention is not required pagdating sa utility model. Okay? Hindi daw required. Pangalawa, the maximum term of protection is only 7 years compared sa patent na 20 years. Both reckoned from the date of application. At pangatlong difference nila, the provisions on utility model dispense with its substantive examination and prefer for a less complicated system. So sinabi na natin kanina 'yon, no? Na less rigorous, no? Kumbaga hindi ganoon kabusisi kapag utility model unlike a patent. So Supreme Court na mismo yung nagsabi niyan. So three aspects, ang utility model hindi kailangan ng inventive step. Ang pangalawang difference, ang patent protection ay 20 years, ang utility model ay 7 years lang. Pangatlong difference, ang patent mabusisi, ang utility model hindi mabusisi. Okay? Industrial design. Okay, so kanina utility model, ano naman ngayon ang industrial design? An industrial design is any composition of lines, colors, or three-dimensional form, whether or not associated with lines or colors, provided that such composition or form gives a special appearance to and can serve as pattern for an industrial product or handicraft. So, what is an integrated circuit? So definitions na lang to mga kapatid ko. Okay? A product in its final form or an intermediate form in which the elements, at least one of which, is an active element or some or all of the interconnections are integrally formed in and or on a piece of material and which is intended to perform an electronic function. So, why discuss all of this? Why present this to you? No? Kasi nga, part pa rin siya ng subtopic ng patent. Baka mabigay. Okay? So, baka, at least by definition, alam mo, may idea ka. Okay? So, ano pa? Layout design. It is synonymous with topography. It means three-dimensional disposition, however expressed, of the elements, at least one of which is an active element, and of some or all of the interconnections of an integrated circuit or such a three-dimensional disposition prepared for an integrated circuit intended for manufacture. Ano ang terms of protection nitong industrial design, circuit, layout, topography? The registration for an industrial design is for a period of 5 years from the filing date of the application. The registration for an industrial design may be renewed for not more than 2 consecutive periods of 5 years. So remember this, baka mabigay. The fee should be paid within a year, etc. Industrial design registrations are governed by some of the same provisions that apply to patents. Yun yung problema eh. Kaya ako siya sinama dito. Kasi masyadong general yung binigay na syllabus ng LECPA, no? Since the same provisions ng patent kasama, isama na natin. Okay? Summary. Okay, tapos na tayo sa patent. Let's summarize the applicable laws or applicable concept sa patent, no? So let me use my notes nung ako'y nag-aaral pa, no? Let me use my notes nung ako'y nag-aaral pa sa law school, no? Under uh, my one of favorite professors, no? Yun. Kung sabi ko nga, no, kung gusto nyo ng maayos na intellectual property na textbook, however, law school ang approach, either, of course, highly recommended ko yung book ni attorney Ernesto Salaw na professor ko sa intellectual property talaga. At yung author, yung textbook ni Judge Rusil, no? Judge Rusil Aquino Tambasakan. Okay? ni Judge Rusil Aquino Tambasakan na maganda rin yung intellectual property na textbook niya. Professor ko naman siya sa Civil Law Review. Ay, Commercial Law, sorry. Commercial Law nga pala. Commercial Law Review, no? So, okay, maganda yung mga textbook, no? But for this one, sa summary, ang gagamitin natin yung mga galing dun sa textbook ni Attorney Salaw, no? Na note ko rin naman nung ako'y nag-aaral pa. Okay? So, to summarize all the concepts, all the applicable laws or mga takeaways, yun na lang yung isipin natin. Ano yung takeaways natin sa patent? Kasi after this, we will proceed to trademarks na. So, mas mahaba, no? Pero mas exciting, mas maraming cases kasi doon. Okay? Sa patent, of course, tandaan mo na not all inventions are patentable. Okay? Not all inventions are patentable because there are only considered are sorry, because there are the law provided specifics for those which can be considered as patentable invention. Okay? So not all inventions are patentable. At para malaman mo kung patentable siya o hindi, an invention must be novel. Okay, yung requisites, tandaan mo ha. An invention must be novel. It must involve an inventive step. And it must be industrially applicable for it to be patentable. If it does not involve an inventive step, anong pwede siya? Pwede siyang utility model. Okay? If it does not involve an inventive step, then it can be registered as a utility model. Okay? So under the Philippine law or the Intellectual Property Code, Philippine law under our jurisdiction adopts the first to file rule, no? And in relation with the first to file rule, the filing date in the patent application is accorded only when the requisites are present. Papaulit-ulit ko yung sinasabi, di ba? So filing date is not just the date when the application was filed. Okay? If an invention is done in the course of an employment, the employer shall own the patent if the invention is part of the duty of the employee. If not, the employee shall own the patent even if she or he used the time, facilities, and materials of the employer. Patent registration is valid for 20 years counted from the date or from the filing date of the application. Uh, Pwede kahit sino mag-oppose or even to petition to cancel the patent. The patent owner has civil, administrative, and criminal rights against the infringer. Okay? However, tandaan mo yung nasabi natin kanina, no? Ang criminal action may only be instituted if the infringer is a repeat offender. Okay? Is a repeat offender. Tandaan mo tandaan mo. Pwede lang ang criminal action sa infringement, ng patent infringement, kung si infringer is a repeat offender. Okay? If the infringer is a repeat offender. What else? The infringer is presumed to know the existence of a patent if there is an indication of Philippine patent with the number of the patent on the container, packaging, or on the article itself. Okay? Nabanggit na rin natin kanina yan. A prior user in good faith has the right to continue using the invention in his enterprise or even assign it and transfer this right. However, may limit na binigay yung law. Ano yung limitation sa transfer or assignment? Kailangan kasama yung business enterprise niya. Okay? So licensing agreements covered patented products or process that are regulated by law. Okay? So let me end this lecture, our lecture for with a quote, no? Let me end our lecture on patent with a quote. We are always more afraid than we wish to be, but we can always be braver than we expect. So this is our quote from Robert Jordan, Lord of Chaos. Okay? So kung umabot ka dito sa dulo, maraming salamat sa pagtsatsaga mo. Again, I really appreciate kung nakakaabot ka hanggang sa dulo ng lecture. Alam kong yung next part ng patent, itong last part ng lecture natin sa patent medyo boring na, no, kasi masyadong technical. However, kailangan nating daanan for us, or for me, no, for me to be able to prepare you sa Sipale. Maganda ng sumobra, again, yan ang katwiran, maganda ng sumobra kaysa dun ka magulat. Okay? Kaysa dun ka magulat. Maganda na yung pasadahan na lang natin lahat kahit papaano. Okay? So maraming salamat sa pagtsatsaga. Again, thank you everyone and have a good day, night ahead of you, week, kung ano man. So maraming salamat. God bless you all and keep safe. Thank you everyone.